Hello and welcome to the Kenneth Verkaman Law Office Legal Podcast. In this edition, we talk about the administration of estates. The new probate law and court decisions made a number of substantial changes in probate and the administration of estates and trust. For example, the New Jersey Supreme Court, in the case of the matter of the Estate of Stockdale, held that where there is a confidential relationship coupled with suspicious circumstances, undue influence is presumed and the burden of proof shifts to the will proponent to overcome the presumption that the will is no good. In this case, neighbors had an elderly nearby neighbor do a new deed, transfer a house, and do other things prior to her death. The Supreme Court held if there is undue influence in the making of a will and the transfer by deed of a house by persons in a confidential relationship, this could subject those persons to punitive damages in some instances, plus voiding of the will. That was in the matter of the Estate of Madeleine Stockdale, docket A-121-06, decided July 22, 2008. The Probate Law, Senate Law number 708, made a number of substantial changes to the provisions governing the administration of estates and trusts in New Jersey. The adoption of portions of the Uniform Probate Code attempted to bring greater uniformity to the rules governing testamentary and non-testamentary transfers to make most state laws similar. So they addressed what's called almost wills. This law expands situations where writings are intended as wills would be allowed, but requires the burden of proof on the proponent to be by clear and convincing evidence. So possibly a Christmas card with handwritten notes could be presented to a court as a will or codicil. To present a non-formal will or writing requires an expensive complaint and order show clause to be filed in the Superior Court in a hearing in front of a Superior Court judge. So be careful, have a will done properly by an experienced attorney. Now the Uniform Probate Law, also helped make things easier for everyone. Now, an old probate law required one of the two witnesses to travel and appear in the surrogate's office to sign an affidavit to certify they were a witness. This often created problems when the witnesses were deceased, moved away, or simply could not be located. Some witnesses would require high fees simply to sign a surrogate paper. My grandmother's will was not self-proving, and the witness to the will extorted a $500 fee. The New Jersey legislature later passed a law to create a type of self-proving will, where the person signs, two witnesses signs, then the attorney notary must sign with certain statutory language. Make sure any will is a self-proving will. Some law offices ignore the new will and don't do self-proving wills. Now, the elective share for a spouse was not changed. So, currently, a spouse who is not given money in a will can challenge the terms of the will. This is called electing against the will by a spouse. The spouse could receive up to 1/3 of the estate, even if only married for 2 weeks. The spouse must file a carryout lawsuit in Superior Court. We suggest a formal prenuptial agreement in second and third marriage situations. The Uniform Probate Law states that a testator now means both male and female individuals, removing the term testatrix. Will forms used by attorneys will need to be revised. Let's say there's no will. Let's say under the old law, if someone died with a spouse and children, the spouse only got the first $50,000, then the spouse and his children split 50-50. So if someone was married for 50 years, under the old law, the kids got almost half. The new law made substantial changes, so the surviving spouse is entitled to a larger share of the estate. And if the spouse is the administrator, no bond is required. In the effect of divorce also was addressed in the Uniform Probate Law, that in the case of a divorce or annulment of the marriage, this revokes not only the prior will, but also non-probate transfers occurring by death to the former spouse. Let's say there was accounts payable upon death. In any case, a separated divorced person should prepare a new will anyway. Now, under federal law, there was also changes to federal, state, and gift taxes. The amount to leave without federal estate tax was increased to $3,500,000 for 2009. For 2010, there's no estate tax if the person dies in that year only, but then it's reduced down to in the year 2011 to $1 million. And after that, we're waiting for Congress to decide. The gift tax amount permitted was increased to $13,000 per year per person in 2009. So you could, for the purpose of federal gift tax, you could give as many people as you wanted $13,000 without incurring a tax. However, the amount permitted for Medicaid nursing home situation transfers is still zero. Now, New Jersey law requires that a copy of the federal state tax return be filed with the Inheritance Tax Bureau. New Jersey has an estate tax and amounts over $675,000. So even if no federal state tax is due, the estate still must file federal estate tax return plus New Jersey state tax return. The New Jersey Inheritance Tax Return instructions were revised in 2008. The L9 resident decedent affidavit regarding real estate tax waivers was revised in 2007. So throw out any old forms. Even if there's no inheritance tax due, a tax waiver on the house must be obtained and filed if the house was not co-owned by the spouse. Now, regarding powers of attorney, don't use a form purchase online unless it contains reference to a New Jersey statute requiring banks to honor the power of attorney. That's Section 2 of PL 1991, Chapter 95, NJSA 46:2B-11. For additional information on estate administration, on say probate and other related issues, call the Law Office of Kenneth Buchanan, 732-572-0500, 2053 Woodbridge Avenue, Edison, New Jersey, 08817. Website www.njlaws.com, that's njlaws.com, or centraljerseyelderlaw.com. Thank you.